Good afternoon, folks. And here we are at, this is 26, picture 26, and we're going to pick up, indeed, at point E, am I not correct? And this is the stalking warning letter with the Dover Laconia Police Department filed by GAL in response to this. Okay. We've seen this. What is this, when you say wrongly filed a stalking letter, the person believed they were being stalked? What do you have that makes that a wrongdoing? If she felt threatened or something, why wouldn't she have the right to do that? Or is it just that she's putting you away and so you can't contact her that you're complaining about, or what is it?
Well, it's wrong on multiple levels, Mr. Chairman, and the impetus for the stalking warning letter was my correspondence of June 3rd in my capacity of pro se litigant. So I was, in fact, corresponding with her in the course of court business. There was no, and that's in the packet, and it's, I hand numbered the upper right-hand corner with a 4,6. And then there's a document called Service of Warning Stalking Letter that I hand wrote just the number 6 in the upper right-hand corner. And it's wrong because I have every right in the course of court business, as a self-represented litigant, to correspond with her for the purposes of, and any reasonable person would look at my letter with her and say that it was not stalking, harassing, or in any way a violation of the stalking or harassment statutes. And I believe that because of the nexus between the email and the stalking warning letter, that it would actually fall under a false police report, filing a false police report, because she had no reason to believe that I was stalking her. These are the only two documents that there is no link in the chain between these two documents. So she knowingly and willingly filed a police report with no reason to believe she was being stalked or harassed.
I'm looking for number 6. You said this is 4 and 6. Where's the second document where she's responding or sending in the request for a...
One of them is a Gmail email that says it's captioned request for clarification.
Right, that's your letter to her.
Yep, and then the stalking warning letter.
Or I mean the warning, yeah. Where's that?
It should be right in the package, maybe right behind or in front of the...
I see it right behind it is a further, maybe it's a further motion to exceed fees.
And if for some reason I fail to include it, I'll pass my copy around so that, and you're welcome to keep it and make copies of it.
Yeah, I see why I haven't found it. So if you'll just go ahead and look at that and pass it, folks, as quickly as you can. Representative.
Page 6.
We're looking at a thing that says 4.6, but we only have the part where he's making the request.
In the back, keep flipping.
He emails at 4 and 6, and then number 5 is, I believe it was, and that's, a couple things which I guess number 5 and number 6.
Oh, there it is, yeah, 6.
Number 6 is about 12 pages after.
Right corner.
I get it. All right.
And Mr. Chair, if I may add,
Wait a
the
second.
third reason why I think
That's
it's
wrong.
wrong.
Can you give that back?
Yeah. Thank you.
Thank you.
So she actually didn't identify a particular pattern. She said you engaged in a pattern, I mean a particular event. She said you engaged in a pattern. In other words, was there a hearing regarding that or something in which she explained the pattern?
Oh no, no, there's nothing. All there was is this email. That's it.
You sent an email.
Yes.
She never had to explain to the court what the pattern was?
There was no court involvement. It went directly to the police after my correspondence.
All right.
I have a question.
I'm finally with the representative party.
Person emailed I guess first of all, with the police thing, was that the only document you received from the police about it, or was there some sort of report they were issuing?
This is the only document I received from the police.
So you don't know exactly what behavior she said in the
No, I was not alerted to any behavior
Did you
specific.
request of the police any further
Yes,
supporting documents?
Yes, I did.
They say there weren't any?
And they said there were not any. All there was the verbal report of the guardian ad litem, Tracy Burnson. It's a verbal report. And what ensued after this letter was a hearty, lengthy debate with the lieutenant of the Officer Pianazowick from the Dover department. His name is handwritten down here. And he and I had a lengthy chat about why he had no cause of action. And he said, in closing, Mr. Youssef, if I thought there was a reason to charge you, I would have already done so. And I said, then we're wasting both of our time on the telephone right now. And I haven't heard a word from either of them since.
Representative Hardy.
In the email, first you explained that they do not engage in any threat of any kind. You say what you said is not a threat, and yet she persisted in assuming it was a threat, which so I guess she's disregarding. I guess she's assuming she can decide what's a threat and what isn't, and not leave it up to you. But you did say, you also said if you, let me see, you did say like there've been past allegations of threats. You made statements which she was trying to say were threats, even though you were explaining they weren't threats. But you want to explain briefly what that was all about?
If you could point me to the
I was
part.
talking about the last paragraph in your statement, but I am not convinced that it's criminal.
Well, I mean,
Go ahead and answer, go ahead and respond.
I guess the only plausible answer I could give, if I were in her mind, was she felt threatened that her licensure may be compromised by my challenging of her behaviors, but that would constitute more of an administrative fear, more so than a criminal fear.
Unless you say to her that you have alleged in the past, you say, as you have alleged in the past, this isn't a threat, as you've alleged in the past.
Yes, because
You've
she.
alleged previously to the court or other places?
When I challenge her, the propriety of her behavior under the license, the GAL board ethics rules in the 500 series, she took those as a threat, and I made it very clear here. This is not a threat. This is an administrative challenge to your conduct. And then she then took that administrative, whatever she wants to call it, threat, what have you, and she filed a criminal
Answer the
complaint.
question.
Yeah, so she persisted in sending these threats even after you stipulated they weren't threats, and somehow she continued to
We got
defy you on this.
Correct.
So,
We-
and now, you're asking for us to decide that this is somehow unlawful or something like that. I'm not so sure. I mean, a person can feel whatever they want to feel. She said you're stalking, if she says multiple threats, if she believes there are multiple threats. Wouldn't this be a little thin place for us to stand? Would you really want us to be here?
Well, I mean, I believe that it's a clear-cut false police report. I mean, she had no reason to believe that this was a criminal behavior.
Representative Izzo.
Thank you, Mr. Chairman. I'm going to endeavor to look it up, but such things have very specific definitions, like bodily harm, and
In the police report, Representative, about 8 pages back, beyond 4 or 6 are, you'll see the police report itself, which gets into that a little bit.
well,
I know, you go ahead and look it up, please look it up for us.
yeah, I guess my point is, if he was, you mean prior, not.
No, I mean way back, toward the back, halfway back through the file. It says service of warning stalking letter, and then it cites RSA 633.
Can you show me what I'm looking for?
It's number here, 6, way back, right in the middle of all the paper.
Number 6.
Number 6.
We're at number 6.
It's item, document 6, whatever, number 6. And then it cites RSA 633-3-A. You have that, Representative Fisher?
Oh, that's a good area.
What is that again?
You were already at it.
633:3-A.
That's here, I didn't see any color.
And there's threatening a class A misdemeanor for the first offense.
Just go the wrong way.
Second offense.
You may be going the wrong way.
Oh, no, he's got
Got
the
it?
camera.
So where is this going? Where is this complaint? This is my complaint.
Regarding that lighting.
Okay. Okay.
taking
Is
it
it
upon
clear where we
herself
are?
to
Is it
decide
clear where we
whether or
are,
not
Representative?
she's being threatened.
Okay, 633, what?
Colon 3.
633:3 dash A, yeah, stop it. Dash A.
All right, what do you want to know?
No, nothing, Representative, this has been.
He can,
Oh, he's got it, okay. Well, look up, we're just trying to find out what is involved, does the kind of thing that he's alleged to have done. Actually, I don't know if we need to do this, considering we don't have documentation of what her other threats, what she was claiming were the other threats or anything like that. We just have the word.
I have it right here,
Could he,
633.
Oh, you did?
right?
Yeah, 633, yeah, I have it here.
You mind passing those?
Basically, personally knowing where
You want it back?
Well, it's my stocking quarter.
No, pass it to Paul.
here, get it. Paul?
Okay. Order the court, order the court. Is this the?
This is not a court.
Wait a minute, guys.
Yes, it is.
Oh, that's space. Like a fucking squirrel. No, in fact, it's getting like a Three Stooges court, it is, but, yeah, I'm trying to keep my hand off the gavel. Representative, it's his right.
Which would cause a reasonable person to fear for his or her personal safety or the safety of a member of the person's immediate family. In fear for his or her personal safety or member that, okay. All of these refer to physical danger. Like he was going to, take out the complaint and hit her over the head with the complaint.
There must be at least two, or there seems to be a pattern.
Representative, let's finish that up. And I
Well,
want to-
so the point is that a threat to report somebody for their professional conduct cannot be considered a threat to their personal safety.
That's the way you read that.
Yes.
So I look forward to seeing that. Oh, is it, you guys sent it back?
It never
Oh,
made
it's
it
not the
there.
same? Oh, it's okay.
No,
It's
it's
not the
not.
same statute. Okay. Thank you. That's fine.
it was G.
He's gonna go.
Okay, I-
What?
I called you recognize too.
I know. I'm still on a point, you have to wait your turn.
I mean, so, it's just not, it doesn't fit the claim.
Okay. Representative Avard.
Thank you, Mr.
followed by
Chair.
Morgan, and then Lambert.
I'm just asking for a clarification. This is what the guardian ad litem filed,
Correct.
not your ex
That's the guardian, this is the guardian ad litem
filing a report.
Is this a follow-up?
with the police.
Yes,
Yeah, go
thank
ahead.
you, sir. So it is the guardian ad litem filing this report
Yes.
in behalf of the child?
No, on her own behalf, as a criminal complaint with the police against me for writing a letter in my procedural capacity of pro se self-represented
But you
litigant.
have
Follow-up?
another four follow-up, yeah.
Is she an attorney?
Yes, she is.
Representative.
I know that, but I'm just for clarification for the cameras.
But it's not right. It's not-
I'm kidding,
that's not talking
I'm kidding.
about this, okay? I will consider you out of order if you talk to the cameras. Instead of working
Yes,
with us,
I'm for the record, I should have said, for the record.
especially if you mean to talk to the cameras.
For the records. So basically, for the records, that this is a guardian ad litem who's very aware of the law and very aware of statute, wrongfully filing, for what purpose?
I believe it's bias and vindication.
Wait a minute. We're not going into motives. There can't be an ascertained place beyond that. Representative Morgan.
So the GAL took it upon herself to decide that she was threatened, even though you had explained that she shouldn't feel threatened. And of course, the other issue is she may have physical safety, since you have said you were angry about it, although, but obviously, of course, you had reason to be angry too, and she knew that too. So like, your problem is basically she claimed to be threatened when you had, after you had repeatedly explained that she had not been threatened. Is that the problem?
That's correct.
Yeah.
And the anger
That's
issue
not
is,
an answer. Representative Lambert.
Thank you, Mr. Chairman. As I see it, the guardian ad litem has a role which is to defend the best interest of the child in a court proceeding. And in this case, while within that role, has filed a complaint against a citizen, which is outside of the role of guardian ad litem. Yet, because they are draped with judicial immunity. If they were to have participated in a bad act, they might be exempt from any redress of that wrongful bad act of retaliatory behavior. And it appears to me that this letter is clearly retaliatory behavior for the court proceeding complaint. Is that right?
That's correct.
Representative Sorrell.
Yeah, as long as we're filing on the guardian ad litem, I'll add too that attorneys, when it's a violation of professional ethics to prefer a complaint or file a complaint without having a good faith basis to know it's supported in the law. And that requires a good faith investigation, and doesn't appear there was any investigation made.
Representative Kepler.
Thank you, Mr. Chairman. We're talking about one letter that the petitioner wrote to the guardian. If you look in 633:3, Roman numeral 2, subparagraph small a, it says course of conduct means 2 or more acts over a period of time, however short. If you wrote one letter, it would not be 2 or more acts.
On the other hand, what we have in front of us is one letter. Do we know there weren't 8? And I'm not saying there weren't by any means, but I'm saying, are we working on the assumption that there weren't previous letters? Just because the witness says so. I worry about that part of our job.
Pointed out.
I'm by no means just saying there are, but even if you say there never was another one, it doesn't help us any.
Yeah. With your permission, if there is a justice of the peace in the room, I'd be willing to swear under oath that this letter is the nexus, or excuse me, the nexus between the stalking letter, warning letter, and the fear of stalking is this letter that I wrote to her. That does not preclude the possibility, because I've been challenging her administratively in the same way that I'm utilizing lawful remedies to obtain redress. This is the cause and effect right here.
Well, no, this is easy for you to understand what you're saying. We're not having trouble with that. I wonder if we would be presumed in this world, Representative Sorbo, if you could help me, it could be presumed in this world to be having expected her to have made other complaints previously. I mean, if they had, they would pursue still in the absence of them. I can't imagine that you wouldn't have brought them in, or I should have said, I can't imagine that you would have brought them in. But in the absence of that, I find myself in a kind of a quandary about accepting this information in a limited way, even though I don't disbelieve you. Representative Lambert.
Thank you, Mr. Chairman. We talk about in this committee and legislature and in the expectation of the public in general of a certain bad act having consequences. And filing, even if there's only one of these letters coming from the guardian ad litem in her role, my recollection is that we've prosecuted more than one individual for firing one bullet. Whether or not that bullet hit anyone or did anything else. Firing a bullet in your backyard, contrary to the expectation of good order, is a crime. This is clearly a crime.
If the crime alleged, if there was a crime that said you can't fire 8 bullets, and somebody said, I got a bullet that came in my yard, therefore he fired 8 bullets. We're looking for this crime had to have, for it to be a crime, there would have, for her to assess, allege there was a crime, she would have had to have had 2 or 3 other situations show up previously, right? Isn't that what we're hearing from the law, that would have had to have been the case, or slightly different?
2 or more acts.
Representative, do you want him to speak first?
No.
You don't want him to speak
Not
first?
yet.
All right, Representative.
But to bank off of what Representative Swart said, that if this actually did happen, if she was being actually threatened, then she should have called for an investigation, which there's no record of any kind of investigation on this particular so-called crime.
Right. Right. No, that's a good point. I'm not saying that.
And
I'm not
if I may
saying-
follow up,
yeah.
if it would satisfy the committee, I would like to put them under oath, under penalty of perjury for this particular item, if that would satisfy the conscience. so that we can move forward.
We can move forward with that. Representative Sorg, would you have a comment on that, the use of the, what you explain to us, what we were talking about, what you were talking about with regard to investigation and that sort of thing? How does the rule work, or the law, or whatever it is?
Well, when I first started practicing law, and I realized I can file these writs, I can really make someone's life miserable by filing this writ of summons and starting the process going. And in fact, it's a restraint on our enthusiasm. It's a violation of the Code of Professional Responsibility to institute an action against anybody without having made an investigation to satisfy yourself that there's a good faith basis for pursuing it. So to just take a phone call, maybe take a phone call from a person and say, well, my husband's talking, okay, and then turn around and calling the police and saying, this person said her client her husband is stalking her. Do something about this.
And where are we left in vis-a-vis this point, though, in the second part of that, which is this witness wouldn't have brought in all the evidence against them, show something else. I don't believe for a second that he's a liar. But doesn't it leave us in kind of a precarious position not to know whether something like that took place?
We certainly don't have any objective proof here. At least
Yeah,
not that I've seen.
objective. Yeah.
It's not a big point, I think, in the whole universe of this case.
Would you mind letting him go first, because he hasn't spoken yet? Representative Willett.
I'm just trying to get everything together. First of all, I can't associate the letter that you talked about with the restraining order. Because I look at this warning letter that you received, and it states here, first of all, the police did investigate it, it says.
Well, I mean,
It says here that they did investigate, whether they did or not, I don't care, but it says, the Dover Police Department has recently investigated the complaint about the behavior. So it was an investigation, let me continue. And then down here, what it states, it talks about a person repeatedly appearing outside their home, their workplace, and so on as being a problem. So is that letter really the cause of the stalking letter, or was there a case where you did contact her or go to her place of her phone?
never outside of my capacity as.
Don't think capacity.
Well, no, because there's an expectation that when she assumes the duty of guardian ad litem, that she is going to assume certain liabilities and a certain role. And that role necessarily involves communicating with the litigants and the parties and or their attorneys, depending on how they're represented. And I can tell you, and again, I'm willing to swear an oath to this, this is the last correspondence I ever had with this woman, even as we sit here today. And this predates this. So the argument that I'm making is that she has a certain expectation. When she assumed the appointment, she assumed certain duties that the position charges her with. And so
contact with you, to put it short.
she has an obligation to have contact with me.
From your point of view, been colored by the fact that she clearly had extensive contact with the mother of the child, who's persisted in taking her own view of the situation, even after you explained what's really going on to her, both in the court proceedings and before. So she could have been colored by the fact that she's been had extensive communications with this person who sort of persisted in opposing your view.
To answer your question, it's no, because the opposing party, my ex-wife, is represented by an attorney,
Yes.
and I was representing myself. And so there was ongoing communication between the opposing counsel and the guardian ad litem, and in order for me to maintain objection and to maintain and preserve my arguments adequately, it required that I communicate with her inside of that framework of the proceedings, which is the only capacity that I communicate with her.
Yes, thank you, Mr. Chairman. Youssef, we have the service of warning stalking letter.
Yes.
In the first sentence says the Dover Police Department has recently investigated a complaint about your behavior towards the above named individual.
Mm-hmm.
There's nothing there that states that the complaint was about an email or any particular thing. The last sentence also just says, please consider this a formal warning that you to stop that behavior.
Sure.
Again, there's nothing saying what behavior it was, whether it was an email correspondence, whether it was, you know, parking outside of her driveway.
Sure.
Have you ever seen her police report, or do we have that police report that shows what the actual complaint that she made was?
I was told by, I think it's Sergeant Dennis Ashley and Officer Pianizek that it was a verbal report. And I'm well aware of my rights, and so I demanded all of them. And I wanted the police report. And they told me it was verbal. So this letter here was served upon me, and the first line in the letter says, Dover Police Department has recently investigated, et cetera, et cetera. But wouldn't an investigation involve contacting me before serving me the letter? Because an unbiased investigation would involve talking to both parties, the complainant and the person about whom the complaint is made. And so this was the first knowledge of this police report that I received. So I believe that it's an untrue statement that a full investigation was conducted, because I would have gotten a call that said, Mr. Youssef, we just received a phone call. Can you tell me a little bit about your position? And then if they continue to have a reason to believe that I was engaging in misdemeanor behavior, which I wasn't, then they would issue the stalking warning letter. But I never received any sort of correspondence.
Let me follow up on his question, if you don't mind, Mr. Harris. Actually, why don't you follow up first?
No, I guess I was just going to say, thank you, Mr. Chairman. I was just going to say that I've never been involved with a stalking complaint, but I'm a little bit taken back, to tell you the truth, that the police would take just a phone call and investigate on that basis without something in writing from the complaint, or at least meeting with the complaint. So what you're telling me is that the police department of Dover received a phone call complaining about you, and based on that, they
Yes.
presented a stalking.
Yes, and I've never been presented, even notwithstanding my demands, I've never been presented with any sort of written complaint.
And so in my follow-up for you, as I was trying to butt in on him earlier, my follow-up for you is, did they not have a written report of what they received in the phone call in anywhere in their logs or anything like that?
They may now. I haven't been in contact with them since I had my hearty
What
debate
do you
with.
mean they may now?
Well, if maybe somebody transcribed the conversation or made a written report based on the conversation that I
You didn't
had.
ask for a police report?
Not subsequent to this
A
because,
police log report of any kind
no,
at that time?
only upon receipt of this letter.
Yeah.
Because I wanted to know everything, all the
No,
information.
just answer it simply. You asked for a copy of whatever they had in
Yes.
writing that they had put down
Yes.
relating to the phone call.
Correct. And I
They
received
didn't have
nothing.
anything.
That's correct.
Did they say they didn't have anything?
Yes, they did. And that was, I asked
And that was
Ashley
how long
first,
after? And that was how long after?
the day I received it. The day I received this letter, I asked.
Well, no, so you're saying then that because that was only a day later, they may not have transcribed anything?
Well, no, the day that I received the stalking letter is the day that I made the demand for all of the, I want to know
No, I
everything that's.
understood that.
Okay.
So you're saying that they, at that point, hadn't transcribed anything into writing? Did they say it like that to you?
No, they didn't.
Okay.
I'm only conjecturing when I say
No,
transcribe and what have you, because I don't know what
Well,
they're
it's
doing.
verbal, they would have had to turn
Sure.
it into writing.
I would assume
That's
so.
what I call transcription. Representative Keynes, I believe. Oh, no, Willett, I'm sorry, Trombley's not.
Mr. Chair, thank you. This is very interesting. Under protective pursuant to the section, it says it's not to be construed to prohibit an attorney from, or someone representing him, anyways, that's an exemption, that from contacting the plaintiff for a legitimate purpose within the scope of the civil or criminal proceeding. So in other words, you're actually a pro se, you're representing yourself as an attorney.
Absolutely, yes.
So you had to contact her because you're representing.
Yes.
So there's your example, 633,
Yeah.
3D.
Representative Keynes.
Have you ever posted descriptions, remarks, innuendos about your ex-wife on the internet, including the description of her vehicle and things like that on the internet that preceded this issue we're actually talking about right now?
That described my ex-wife's vehicle?
Pardon me?
That described my ex-wife's
No,
vehicle?
not your ex-wife.
Right. Well, the GAL.
Oh, yes, I believe I have, yes.
You have what?
And that,
I'm sorry?
You just admitted to something.
Oh, no, I mean,
You attacked and whatever, went and talked about the GAL online.
no, I didn't attack her. I didn't.
What did you do? What did
No,
you
I
do?
just said that I made a description that her vehicle has her lettering all over it, which is true. It's a true statement. It wasn't an attack of any kind.
Maybe I missed it. Want to follow up?
well, I guess some people might perceive having my car with lots of descriptions and other remarks about me on the internet as slightly close to a threat.
Right, which would be nice to have a police report where we hear that specifics of an allegation.
However, I mean, in response to that, I would say that if somebody who's in business is lettering their vehicle, it's to be noticed. So, I mean, there's that argument there.
Well, that's what the presumption would be, that if you pointed that out to people, it would be for purposes of intimidation.
There was no purpose for intimidation. If there was, I'd like to follow up, that there would have been a charge brought. The officer to whom the complaint was made said, Mr. Youssef, if I ever thought there was something I could charge you with, I would. Because I basically demanded to be charged or we're getting off the phone. There's nothing to talk about.
Representative Lodge.
Excuse me, thank you, Mr. Chair. I appreciate your,
Not forgetting.
allowing me to talk with the, Mr. Youssef. If a person does do a stalking order, do you believe that that person has rights to anonymity?
You know, I'm not sure if I'm not sure how to receive that question. I'm not a lawyer and I'm not sure that my opinion that much matters. I believe that under the New Hampshire Constitution, that when a complaint is brought against somebody.
Would you express something that's relevant to the?
Well, I'm curious about the fact that she would deserve privacy.
I think she waived her privacy when she put her name on that letter, or when the police put her name on the. She didn't ask to have her privacy.
Does that help us to understand whether or not she had did something wrong in writing a stalking letter?
No, it doesn't present any kind of wrong. It presents the fact that she gave a statement. And I'm curious as to know whether or not Mr. Youssef thinks that his being privy to that knowledge is appropriate or right.
Well, I mean, to be honest with you, with all due respect, it doesn't really much matter what I think. It's really the case is a public case file, and it's not sealed. No part of it's sealed. So there is no expectation of privacy for her when it comes to the confines of the case file. It's open for any of us to look at.
Representative Caput.
Thank you, Mr. Chairman. My curiosity pertaining to the seriousness of this letter is the fact that Burnson was the complainant, but the only 2 copies of this letter was the original to the individual being served and a copy to the police department. The complainant didn't even get a copy of it. According to this document, there's no copy been given to the complainant. So it must. Copies are down at the bottom of the page. It says original to individual being served and a copy to the police department records. It says nothing about a copy to the complaint.
Interesting point. All right. We're going to move to F. By the GAL ethics rules, 503-06, you're not recusing yourself after reporting that she was fearful of you. Would you, have you got that right in the 501? Is that here somewhere, the law itself?
I don't have, it's in my file from prior hearings. I have provided copies of the GAL ethics rules. It's 503-06A, GAL, and I'm just loosely quoting, GAL has a duty to seek to decline appointment whenever he or she has a prior or present relationship that would adversely affect his or her role in appointment.
Did you request that she withdraw?
I did, yes. I actually motioned for the court to dismiss her. I motioned to remove the GAL which I have a copy of my motion with me. I only brought one copy because I didn't really, but I'd be happy to pass it around.
Yeah, pass it around here.
Wherein I enumerate many of the reasons for the dismissal, which was summarily denied by the marital master and the judge.
You know, you realize that, I mean, I don't think these things would not be something serious, but you realize you would do better to pick on the top end things. And maybe you should even point to those top things first.
Yeah, there's just so many things. I've tried to boil it down
You
to.
understand the difference between really major makers and
Yeah.
things that are on the edge of, they should have recused. I mean, there's so many marginal discussions here about how many things we don't know and do know.
But the problem with not recusing is that it has a material effect on my substantive rights. With her not recusing, it created a domino effect that, I mean, literally destroyed my family. So, and it all hinges upon
That's a
these.
presumption in itself, that would be.
It's actually a well-documented fact, so.
What is?
The fact that her failure to recuse had a
She
material.
then expressly prejudicially treated you.
Absolutely.
She
Well,
said it in words, I hate this guy and I'm gonna
well,
start.
I can't, no, she didn't say it exactly
Well,
like
that's what we're
that.
looking for,
She
though.
treated me exactly like that,
No,
and
that's
she.
an interpretation, no.
But she
That's not-
reported.
We can't go there. We can't go there. We can't really remember.
Mr. Chairman, if a guardian ad litem has the ability to impact the life of either of the parents, and there is explicitly a brewing conflict between the two of them, I question the objectivity of the process. And as soon as this lady files a complaint outside of the court, having nothing to do with the case itself, how can she preserve objectivity in the outcome of the procedure?
No, I'm not disagreeing with you. I agree with all of you. This is true. But what he said was everything else here, and he said definitely was blah, blah, blah. And I agree with you. She should recuse. I'm not disputing this point of him. You understand what I'm saying? He then went on to say that I can show you that she then treated me prejudicially. We can't prove that. You can't prove that. It's not. You can't prove that. Obviously you can't. You're talking motive here.
Follow, Mr. Chairman.
Representative, but I don't disagree. Your point is his point. We don't have to talk about this. Your point is his point. We got that. We got that point. I actually have a couple other hands. Representative Harvey.
Yes, thank you, Mr. Chairman.
I would agree with you.
Going back to E wrongly filing a stalking warning letter, the GAL did not file this letter. It was built with the police department that filed it. I'm very concerned that, and perhaps this happens all the time, the police department would take a stalking complaint without some kind of a written complaint and just issue this letter based on a phone call. I find that very disturbing. I'd like to see what the police reports are.
On the other hand, we probably have enough in front of us. We can file this. I think we put it on memory banks. We are an investigative committee, as it turns out. Clearly, we're not an investigative committee.
Just open another can of worms for me.
I think that's somebody over here. Was that Representative Avard?
Yes, Mr. Chairman, I think that a GAL can totally, on the whole idea.
We do all agree.
I know, but on the domino effect, and this is salient point, it's not a minor point, in that they wield so much power over the family that if she didn't recuse herself, the domino effect is very important, because she carries a great amount of weight with the court.
Right. So but you'd still call it the potential effect. And so the problem, you're recused because of potential influence, bias, whatever it would be. He's established that. That's here. That would be here. This would have made that so. And then he made his motions. I'm not disagreeing with any of that. I'm simply saying, look, he's going to actually try to prove that she then, you'd have to have statements, or you have to collusion somewhere. It goes back to the conspiracy thing. You can't prove that. I don't believe that. But you can show a pattern, perhaps. On the other hand, disagreement with decisions and activities and stuff like that.
There's obviously a conflict of interest, though, immediately upon her.
Yeah, we're not disputing that. For us to be done, I think that would be part of our finding. I wouldn't take that away from you. Representative, I think I'm over here. You have the point? No, I think it was, no, Harding's been up for quite a while. Representative Harding.
Oh, she's in the letter, not to believe in the letter, but the letter, Chief College which I assume he sends out, it's a form letter he sends out to people all the time. It seemed, stopped short of saying that the recipient letter was actually stalking this person, just saying, you know, I mean, the gist of it is, the first gist is basically cool it, dude, and the second part is like, don't start showing up at this person's residence or workplace, you know, with the minimize the physical contact. So he didn't really say you had been stalking, he was probably just saying, escalate to the point where I have to like, he's more sort of trying to warn me things that it could escalate into, like more than saying you've done anything wrong, illegal in the past.
I do recall the officer, and I want to say it was the Dover officer, I spoke with both of them. He did say, and I'm not quoting, this is a letter, a form letter that we send to everybody in advance of charging with stalking. And then at which point I became extremely defensive because I don't like to be bullied unless we have something, a material issue of fact.
We're fine on this point, actually, let's not go further into this. Representative, Representative
Well, I thank you, but I just had my answer from Representative King. Thank you.
did the committee want to hear your answer?
Well, I just want to know about the stalking order itself, what it said.
Yeah, oh, you haven't got a copy there?
I do not.
Do we have extra copies?
For clarification, there was no order.
There was no order. No, right.
We didn't all just back and forth.
You have three people working on
Share
one.
documentation, Mr. Chair.
Yeah, we should have made copies, more copies. Representative, let's just go further back to where we were.
Sounds familiar to me.
Okay, I think we're clear though on the recusal question. I think we're clear. The potential there, the recusal would have been presumed to be appropriate and all that sort of thing.
Yeah, and I just point the committee to document handwritten upper right-hand corner number 7, which is where the guardian ad litem admitted that she was fearful of me. And then she subsequently testified at the final hearing that her fear was the fear of administrative reprisal by me, that I would come after her license. A right that I certainly intend on pursuing.
Fascinating. Thank you. So I think we're clear. Let's go to point G. Improperly recommended suspension of all the petitioner's visitation and parental rights with no findings of abuse and neglect. What's the law related to that you're referring to?
Her recommendations.
No, I know what that, but what's the law you're referring to?
RSA 461A, which would be these recommendations are a modification of a parenting plan apart from the applicable Muchmore versus Jaycox doctrine.
I'm sorry, I lost all that.
I apologize.
It wasn't you, it was the committee.
No problem. The recommendations that she made to suspend my visit and all of my parental rights with my son, including but not limited to not having...
I'm actually still asking this. RSA 461A
11
is where she's supposed to have had findings of abuse and neglect before she could recommend suspension.
No, I'm saying she didn't have standing to, or she had standing, but she did not have, the statutory muster was not met to modify a parenting plan.
And that's in RSA 461A.
Colon 11.
Yeah.
Colon 11. So 461A, colon 11 says something that disallows her to make that recommendation unless there's a finding of abuse and neglect.
I don't
or
think...
anybody else. I mean, that's what you said here. You said improperly recommended suspension without findings of abuse and neglect.
Yes.
So I just rephrasing it in reverse, right?
Yes,
This isn't
but
complicated.
I guess it just in reverse it has different connotations because Muchmore says you can't change a parenting plan apart from 461A11. Yet she did so.
Representative, can you help me with that? Help me with that. She could recommend anything the heck she wanted, it seems to me. I'm surprised that she can't just pick.
No. You can't,
The court would have said to her, then we can't do that without this, but is there something that says she
unless
can?
they didn't.
Well, yeah, unless they didn't, but
And they did.
they did ask her to cite the law that allows her to do that.
Oh no, and the court did approve the recommendations, which is the whole trickle-down effect from...
Does that show up later where the court?
Yes, it does.
Okay.
Yep, paragraph 3.
So, would I be wrong to just push that over to that part for the purposes of this report? And talk about what the judge did? of marital master. Anybody have a view on that? My sense is to do that. She might have had ignorance or whatever else. She might have not known she ever had to be a finding. I mean, I would be shocked to think that, but you're saying that you had a right to know that she had an obligation to know that there was an RSA 461A11 that protected you from a recommendation like that.
Correct. And I would also add that if it was out of ignorance, there is a guardian ad litem ethics code that requires her to either become educated or recuse herself based on her lack of subject matter
This will
knowledge.
be after the fact down the road, of course, something like that. So, Representatives, are you familiar with this RSA that we're talking about here?
Well, I'm just looking at it, and it says, the court would have to find by clear and convincing evidence that the child's present environment is detrimental to the child's physical, mental, or emotional health. And the,
Is that what you meant? Is that what you meant? Or you used the word specifically abuse and neglect?
it doesn't say abuse and neglect.
No, it does not say abuse and neglect. I guess that was put in there as a demonstrative point, that there was no physical harm to the child. Furthermore, as we spoke about earlier before lunch, there was no evidentiary hearing.
Representative, so what it should say is, and does it apply? So what it should say is what?
What RSA 461A:11 says, the court may issue an order modifying a permanent order concerning parental rights and responsibilities under any of the following circumstances. C, if the court finds by clear and convincing evidence, none of which was admitted, that the child's present environment is detrimental to the child's physical, mental, or emotional health.
Right, and so you follow that. Now that's what you would be saying, right? That's what you really truly meant to say. I'm putting words in your mouth.
Well,
the abuse and neglect doesn't apply in this area of law.
I understand.
Well, so we're talking about whether or not that's what you meant to say, and if so, my sense, folks, is that we got put this under the judge's part and not deal with the GAL. It doesn't make any sense to be under the GAL section. GAL may have screwed up, but there's nothing in that citation that says something about GAL, does it? It says the court.
Correct, actually.
That's my point.
That is true.
Can we strike this and just leave it out until we get down to the court?
It reappears under the marital master and the judge, but
Would that be fair enough for you?
That's fine. That's fine for me, as long as it gets recognized as an issue.
Representative Kepler, and then it's just.
Yeah, because the judge should have said no
Kepler,
go.
would you allow it to go first?
Yeah, you can go ahead.
Okay.
Yes, that's right. Because the judge should have said, no, I'm not admitting this.
Yes. We.
They're the gatekeeper.
Representative Kepler.
I think you ought to review 461A5, Roman numeral 3, where it says that there is a problem about the possible abuse, that the court can allow just the evidence of one parent, and then it says if a joint decision-making is granted despite evidence of abuse, the court shall provide written findings to support the order, which would mean that the court would have to give you an order to allow only the testimony of one, or in the decision-making of the change. But you'd have to have written findings from the court to proceed with that, as opposed to having both parents participate.
If I can go back to Youssef for a second, would you? No, go over to you. Avard?
No, I
Wait, not yet. I have two other guys. Representative, so what do you see on that one? Is that more to the point?
Yes, I'm just trying to find 173 which?
Actually, would you just look at that?
No, 461-A:5, Roman numeral 3.
Right, I looked at that, and it references 173 which?
Well, they're talking about abuse, but I was reading down farther in that same
Ah,
paragraph.
it says dash A?
Excuse me?
You said it's 173 dash A5.
B:1, I believe.
B:1 is where it's talking about there.
Okay.
173B:1.
Which is protection of persons from domestic violence.
Yeah, but they're just referencing that at the beginning of the paragraph,
Well,
but
that's-
further in the paragraph, what it's doing is saying if the court can use one person to make a change, but they have to provide a written report of their findings of why they support the order.
And the whole point here is he's talking about a lack of findings, right?
Right.
Am I wrong?
Right.
Yeah, but I don't think he
I
has
have you all in order here. Representative Lambert.
Lambert has two questions. I'm going to state them both and see if I can get answers. First is there a need for a document of finding? And was there one? And was there a decision made that should have had the document? And what happens to the decision if the documents weren't filed and there wasn't a proper change? And I know it's a, I'm not asking for answers, but
I think that's where
You're
right there.
precisely correct.
That's where we're sitting. Representative Delano.
I have some questions for the, Mr. Youssef.
All related to this point. All
Pardon?
related to this point.
Well, relative to guardian ad litem,
No, just this 1.9, a G row. Just on point G though.
which
You
is,
just did the point G. A properly recommended suspension of all petitioners' visitation and parental rights with no findings of abuse and neglect per RSA 461A11 and some others.
no, my question's not relevant.
Hold on, but,
I'll be back.
Ori. Representative Ori.
I was gonna say about what we'll do, G, I think more logical to leave G in here, I'm probably leaning towards voting against the whole report, but G, it is like sort of a three-part thing. Burnson files his report, so that can be agreement. It's unclear whether it says no findings of abuse or neglect, even though we got certainly more than enough paperwork here sitting here. But pages 1 through 10, once again, are not in this packet, and it seems unlikely that there were findings of abuse and neglect based on the little bit that we can see on page 11, but, I guess I'm only 99% sure that she didn't allege abuse or neglect, but it would be better. I feel a little bit more comfortable. But then 3D is a slightly separate charge. That means Geiger is guilty of malfeasance by refusing to see that the GAL report was incorrect, and of course,
We're not in the Geiger yet. But
no, what I'm saying they are two different charges against two different people,
Yeah.
so it's appropriate to leave both in the document.
Take your point, yes. Representative, Mr., do we have the first 10 pages of that decision?
Yes, you do. It was submitted in,
Files?
in prior hearings.
Okay, would you find that?
And I would also like to just by way of reminder, the DCYF complaint that Burnson filed against me was returned unfounded. There are no findings of abuse and neglect anywhere in
And there were no findings at the time of this report, or they were found unfounded at the time of this report?
Yes, they were unfounded before
Yeah.
this report was issued.
Thank you, thank you.
So this report was issued with the full knowledge that her allegations were returned unfounded.
Okay. Representative Delage, did you have your hand up?
I'm sorry, no, thank you.
Yep. All right, so Representative, I guess we're still waiting for you to tell us whether you believe, for what Representative Lambert was talking about, whether you see in either 5.3, blah, 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 all that other stuff, or 461A11, whether this abuse and neglect issue comes up and how it applies, but it may not apply at all if the question is about findings and the findings don't show up in the report.
Well, I think that is the point, is that there are no findings. You
So this doesn't
you
apply.
can't get to modifying parental rights unless you have this finding.
Okay, and that's under RSA what, for the record, as far as you know, or can,
Well, let's
that's
see.
what we would need for our site, for citing it, references. Who says you have to have findings? Where's
That was under,
461A5.
yes, thank you.
461A5?
Yeah.
Okay, all right, thank you. All right. That'll get us along.
That's Roman 3.
Roman 3.
Yeah.
Representative, who am I missing? Did somebody have a hand up? You pointed that way, did this for no reason?
Oh, was,
Never mind. Oh, was your hand up?
I thought you just had.
What is the name of this document we're looking at, so we can give Representative Morgan the, is it notice of decision?
I'm sorry,
Would you mind?
I have so many.
No, would you mind coming forward? and
Yes, not at all.
You can hold it. No, 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 no.
Which one is it?
Is it one?
Yes.
Is it one of those two? Which report was that?
Okay, there's a guardian ad litem report, it's
Right here?
26 pages long. No, this is my motion to remove the GAL. This is another subject.
Summary of grievances, I really don't have them. You know, sometimes there's two.
Why don't you run this call?
Not a time here.
The document
You would.
the first sentence, yeah, so that was the Guardian's letter report that I given to you back in my first and second hearing.
No, he's going to say
It's late. He's not staying.
Let's finish up.
So every now and then-
Lambert.
You might go.
Thank you, Mr. Chairman. I'm curious, and hopefully I can get some help from Representative Sword or someone else in the room. But if we have family courts making decisions that aren't following our procedure or their own procedure, wouldn't this fall under the categorization of decisions that are arbitrary and capricious?
Certainly for me it does.
All of us. It's a question. Thank you. If we have decisions by the family courts that are arbitrary and capricious, wouldn't a simple statement to that fact be a wonderful way to describe the large set of detail that will escape most people, but bring to light the fact that if those standards were used somewhere else, that courts above them would be overturning these decisions left and right?
Take your point. Representative, it's a fellow Dr. Lodge.
Thank you. Just for a point of clarification, RSA 461:5A or whichever, A5, Roman numeral 3, which references 173B:1 for the definition of abuse. A, assault or reckless conduct as defined in RSA. B, criminal threatening as defined in RSA 631:4, sexual assault defined in RSA, as defined in RSA 632:2 through :5. Interference with custody as defined in RSA 633:1 through RSA 633:3-A, which fits what the GAL filed. E, destruction of property is defined in RSA 634:1 through 643:2. Unauthorized entry as defined in RSA 635:1 and :2. And harassment is defined as RSA 644:4. So, though I assume that the citation of abuse ought to have been an issue directed at either the other parent or the child,
You understand, though, that I was asking him to say to us that to tell us whether or not it was actually what he was meaning to say. He said no, he didn't mean abuse and neglect, he meant something else.
No. Under RSA 461-A:5, Roman numeral 3, one of the justifications for modifying a parenting plan is abuse as defined in 673:1, which includes what the GAL filed. One would presume that abuse ought to have been something directed at either the other parent or the child, but I would suspect that's the connection.
Well, the point, though, isn't so much that, is that there's no findings. I
And
think
there
that's
are
all
no
we're talking
findings.
about. That's period, so let's get out of this one.
Well,
Let's go
no,
on to-
that is a pattern
Right.
where allegations are used as, are alleged as finding, and it's not the first time we've seen that.
Right.
The pattern is to make an allegation and call it a finding.
or a judgment.
Okay, and just for our purposes, I take that. And I take that for future advisement, that's very interesting, very interesting concept. Personally, I take that. Representative Delage, I think you're
I
right.
have a question, Ms. Youssef. Thank you, Mr. Chair. The GAL represented your child independently. I am asking you, sir, did you cooperate with the GAL to establish her findings?
Initially, I was highly cooperative until I noticed a pattern of deviation from the professional standards of her conduct, violations of state, federal law, and violations of the ethics controlling her appointment and her stipulation. At which point I exercised all of my rights at all times to challenge her on all bases where she was deficient or derelict in her duties.
Thank you, Mr. Chair. And how did you represent yourself?
As far as my
Your findings regarding this GAL?
how did I represent myself?
Yes, sir.
I appeared in propria persona in court, which is kind of similar to pro se, but it basically in Latin it means I appear for myself.
Thank you.
We're not cross-examining the witness, we're actually just trying to get information.
I am.
Yeah, no, it's fine,
I'm trying
it's
to
fine.
find out what's going on.
It's really a question of tone more
Personally.
than it is what you're saying, but
Oh, I'm sorry.
that's okay.
I just want to know why you didn't cooperate with the GAL.
Because that would be tantamount to me cooperating with someone committing deviations from defined law, constitutional
Give me an example
principles.
of the defined law that way you first.
Well, 50306A, for example. My motion to remove the guardian ad litem cites many examples of deviations from of her responsibility.
Right. So you were citing laws to her?
Oh,
court
absolutely.
that she was breaking?
I mean, enumerated in very, very clear
Do you have
detail.
that in the form that she could have? Or do you
I
have
could
it
follow.
somewhere?
I didn't bring it with me, but I'd be happy to provide it to you. So,
All right.
but I mean, I was exercising all of my rights, and I preserved all of my rights to challenge her and confront a witness against me at all times. One example: she refused to provide her entire guardian ad litem file to me, and I testified to that one of the last couple times I was in before the committee. Under Ross versus Gadwa, she has an obligation to provide her guardian ad litem file to me. She didn't do that. There's a prime example.
Representative Avard.
Yeah, Mr. Chair, we've gone over this case a number of times, and to go back and get more files at the end. seems
No,
to
we're
be
not
like-
looking for files. If
Okay,
she
well,
wants files, she can, it's between them. It's up to you. We're not looking.
but I don't want to
for
belabor
files.
the one, you know,
No,
you
I'm
can just say.
all set. I agree. I take your point. I'm not looking for files. We're going on to point 3 then. Master, we're talking about Master Geiger.
Mr. Chairman?
I'm sorry, I missed you. I really missed you.
Once issues of challenge were made, did the court ever entertain, when issues of challenge were made for professional conduct, did the court ever engage in the conversation as to whether or not the guardian ad litem could fully and adequately continue to serve in the role that they had been previously serving?
No, the answer to that is no.
Would you give a more specific answer to me?
Yes,
I know what you mean.
absolutely.
You
On
filed- yeah, you filed-
multiple occasions, I filed motions to remove the guardian ad litem,
Right.
and they were denied without hearing
And they were on issues of law.
on issues of law. Absolutely, absolutely. I
Yeah. All right, Master Geiger, if we're all set with,
No.
we're all set with GAOs.
Yeah.
Conducted it.
Do you have any of those filings and any of those rulings?
No, but you're welcome. He said he'll provide them.
sure. I'd be happy to
We're
provide.
not
it.
I don't even
we're not
have,
gonna
I
get
don't
to
even
it.
have the pages that were passed out this morning, so I don't expect to get anything more,
Actually,
but
I'm
I do
sorry, I
expect to be
didn't
able to
have-
ask questions occasionally.
No, I think we need to get Chalmers to run back up there and get copies for you good folks who don't know one. In fact, I'll call Tina and ask her. She won't have it. So, but let's, at that point anyway, we'll go back to that if you like. I'm not pushing away if you can't come back. Mr. Chairman,
You want me to look and have copies made? How many do you
Yeah,
need?
thank you. We'll do the same thing. Just make, how many copies do we need? How many people do not have copies of that longish thing? Just like 2, 3?
Oh, yeah.
Get 5 copies.
Okay.
And let's then go on to Master Geiger conducting a hearing that affected petitioner's parental rights without proper judicial notice. Is that what we've already?
We did cover that, and I would refer the committee to the case summary document, handwritten document number 10 in the packet. And that is a partial document index snapshot of the document index from my case. And the 1, 2, 3, 4, 5, 6, 7th entry indicates that this was a trial management conference. It is in no way evidentiary trial for the purposes of modifying parental rights and responsibilities. And like I mentioned before, it was conducted by offers of proof.
Well, that's a different one. So you conducted a hearing that affected petitioner's parental property. Are you referencing, can you reference whether it's requisite for notice is in the rules?
Sure.
Yeah.
Douglas versus Douglas from 1999 was a case, New Hampshire Supreme Court case, which states or holds that one of the fundamental elements of due process is notice reasonably calculated. The notice reasonably calculated is to include the time of the hearing, the date of the hearing, and the subject matter, and whether or not a person's...
So that's a clarification, and I was looking for it, and you actually cite something in the rules, or we're looking for the rules themselves, that they were clarifying.
As far as a rule violation...
Douglas, yeah, where's the rule that you were...
I'd have to flip through the rules of family division.
Okay, that's just my...
But the rules are pretty short, so I could find them for you and email you afterwards.
Yeah, okay.
And say,
Uh,
I do believe I submitted that originally in my two. I submitted several hundred pages.
I'm
Yeah.
trying to figure out why our file's not deeper.
Yeah, I had a huge file from the first couple of hearings, so it was quite extensive.
Representative Lambert, yeah, we should have that. She find it.
Is it my understanding that the exact rules and procedures of the family court are not exactly the same as the rules and procedures of other types of courts? And if that's the case, would Supreme Court decisions about fair treatment of individuals who are before the court might not really apply there?
I would say so, except this wasn't family. Douglas versus Douglas was a marital situation. It wasn't family.
It wasn't, yeah, well, it predated the institution of the family division.
Oh,
It was probably done in Superior Court,
Yeah.
but it was a marital matter, and so the institution of RSA 490D, which is the Judicial Branch Family Division, adopted many of the Superior Court rules, and they were subsequently absorbed by 490F, which is the Circuit Court Family Division.
Did they expressly adopt Douglas versus Douglas?
No, not expressly, but I believe if you look in the annotations to 490D, you'll see a reference to Douglas versus Douglas. Yeah, and you have to look in the annotations. Don't quote me on the citation, but I'm pretty sure.
It's under B, wrongfully recommended the suspension of the petition visitation and parental rights with no findings. We're back to that point, which is the one we just spent a bunch of time on.
Yes.
Okay.
In the expert testimony, I'd like to make it expressly clear that the guardian ad litem is not an expert. She's merely a fact finder. She's a subcontractor, so to speak, of the court. And she engaged no expert opinions in her report. Her report was comprised of her own opinions. And she's not an expert.
Wouldn't she become an expert?
No.
By spending lots of time with the kid?
Absolutely not. She, in legal contemplation, she's not an expert.
Representative Lambert.
Have you read all of her opinions and submissions to the court?
Have I?
Yes.
Yes.
Every single one?
Absolutely every shred of paper, yes.
You refer to in his case, Representative Lambert? Would you help me with that? Why would you ask that? I'm not sure I follow your thinking. Would you help me with your thinking on that so I can be benefited?
Actually, just so that I could make sure that I could use the knife one more time on sealed envelopes that seem to be happening in the family courts with guardians ad litem all the time. But if there was...
In my case, there was no sealing.
If there was no sealed envelopes, then I can't actually use the knife, but I'm going to keep trying.
All right. So we have C then, wrongly compelled petitioner to finance the therapeutic reunification of his son. Now, wrongly, in defiance of...
I would prefer to actually use unlawfully, coerced me into a contract.
Okay, so I want you just to cite the law then again.
Well, I would just cite common law contracts that she recommended that my child be taken away from me in an improperly noticed hearing with all the other problems that existed with that hearing, wrongly modify or unlawfully modify the parenting plan, and then set as a predicate to seeing my child again an arbitrary means of reunification called, quote, therapeutic reunification, which she ordered that I pay for.
So unlawfully is it relates to the lack of a finding here.
Yeah, and
That's the unlawful part.
it is, but it coerces me into a contract with a third party, the therapeutic counselor, and requires that I bear the financial burden. It essentially holds my son ransom against the payment of a payment for a service that the court ordered that I didn't request with a private contractor with no basis for the reunification in the first place. They create the disunification, and then
We're
they...
still back to the point of finding. The word is still a finding, right?
Yeah, well, there's no finding. So I guess...
That would apply to this entire thing.
Yeah, that's the common thread that runs through the whole document. There's no findings.
He utilized the false and incomplete testimony of G.L. Burnson in the decision. Why wouldn't they utilize her testimony? She's the GAL. What's wrong with her utilizing?
The court was duly notified that Burnson had a duty to recuse under GAL 50306A1, and the court paid no attention to that. So I argue that she was operating under color of law, and that every single thing that the guardian ad litem proffered after her declaration that she had a, quote, fear of me is stained by the color of law and should be inadmissible.
Well, let's make it false.
I'm sorry?
Let's make it false. We're on D. We're on point D.
Well, the merits of the substance of her report contained factual inaccuracies and were all stained by what I argue is an improper appointment.
Well, you have to say false and incomplete. You got to stick with your points in this thing here, or at least the points that were reported. That we're referencing from our report. It says false and incomplete testimony.
They're false because the data isn't correct, and they're incomplete because she did not perform all of the duties that she was contracted to perform and ordered by her guardian ad litem stipulation, which is required under Superior Court Administrative Rule 2005-01, I believe it is, which requires a stipulation. So the requirement of a stipulation would impart a duty under that stipulation, and when she fails to perform on that contract, I mean, not only is she in breach of contract, but she's in contempt of court.
Incomplete testimony is what I'm working on here. Testimony, the word testimony. Representative, to help me out.
The point is that
Well, no, would you do me, instead of saying that, would you just rephrase this so what it should say?
okay.
I could see utilizing false to the extent that she used wrong information in her testimony.
Okay,
You're off.
question, thank you.
Yes.
When you say she didn't fulfill all the stipulations of her, all the points of the stipulation,
Yes.
what was not fulfilled?
I will be happy to.
I mean, that should be a fairly
It's a short document.
direct laundry list.
Yeah, it's a fairly short document, a couple of pages. Find it.
I think he's handed it.
Is he? Oh, okay. No.
I have one. Mr. Chairman, may I walk up?
Thank you.
Here we go.
No, I think it's because he used 2 pages. But let's, how many people, last page
This is the stipulation.
weeks ago.
Okay, I can just underline the items that were,
Yeah, I gave him, Representative Swords, did you give him?
that was not investigated.
Okay.
Includes but not limited to the following activities. Includes but not limited to, it means that I would include everything here.
Yeah.
The individual is to be interviewed by the GAI folks. That happened. This did not happen. She did not make a home visit to my home, but she made a home visit to an ex-wife's home.
Let me ask the committee, how many people can or will stay longer for the other hearing? Or should I send the House times? I think we're gonna be here for another hour.
Yeah,
That would
And we
make it-
really shouldn't.
That would make it.
I shouldn't
that would
stay
make it-
past 3.
That would make it 3:30.
I can't stay past 3.
You wouldn't have a quorum then?
We wouldn't have anything like a quorum on betting. That's what I was trying to see is
She never investigated.
my question again, I mean, a lot of committees go work till 6. This is arduous stuff, admittedly.
Because she came into this hearing on February 11, 2011, because she was asked by the marital master specifically, have you investigated where Luke should attend school? And the marital master, and she said no, and then the marital master said, well, then how can you determine, how can you state with certainty that Luke should be removed from Tri-State Christian Academy and put into the Dondero Public School? She said, because children are very resilient, and so she went into expert recipient testimony. She's not an expert on the resiliency of children. She did not investigate at that point in time. That's in the packet.
Now, I understand, so, now.
Representative, I'm getting really closer.
Yeah, we are.
I'm gonna take a 5-minute break. We'll come back exactly at, or I'm gonna,
Oh, yes,
break.
it was a bit of-
Come back exactly at 2:30. We're recessing for